Okay, a very quick introduction to this topic. Some of you might say, well, don't we already have standards? So let me just put two articles from the TRIPS agreement. I think it's fair to say the most important agreement at this point in time at the multilateral level on substantive patent law. And so you see here Article 27.1 that says that there should be inventions available for in all fields of technology, provided that the invention is new, involves an inventive step, and is capable of industrial application. And one of the most interesting footnote in human history says at the bottom, you can see it, the terms inventive step and capable of industrial application may be deemed to be synonymous, I love that, with the terms non-obvious and useful, respectively. And then 29.1 says that members, these are WTO members, World Trade Organization members, shall require that an applicant for a patent shall disclose the invention in a manner sufficiently clear and complete for the invention to be carried out by the FACETA. So that is the end of the introduction, and we will go back to the format that you're now familiar with and open on the for side of this proposition, which reads, we should adopt uniform international standards of patentability. Who wants to start? Professor Strandberg, you want to go first?
Oh, okay, I'll go first. So there are two reasons to be in favor of having uniform international standards of patentability. The first one is probably the most obvious one, which is that we live in an increasingly global economy, and that we have increasingly businesses that operate cross-territorially and need to be able to deal with their intellectual property interests in many different countries at once. Having varying standards of patentability in different places is costly for these companies and makes it hard for them to operate. Also, sort of along the same lines, having varying standards of patentability can permit some countries to become sort of piracy havens, places where things are not patentable and therefore companies can make goods there and so forth. But I actually want to focus on another reason that why we should adopt uniform international standards of patentability. And that is that the process of going through the adoption of uniform international standards, I would argue, will be valuable in and of itself. So some countries, such as, for example, developing countries, may want to make it more difficult to obtain patents. And it may seem like the absence of an international regime and international standards provides them with that flexibility to vary the level depending on their stage of development and other factors. However, what actually happens in the real world is that without an international harmonized regime, countries, such as our own country, the United States, can pressure weaker countries into bilateral side trade agreements that are actually often quite disadvantageous to them, and that can have the effect of ratcheting up intellectual property protection worldwide, which is not what these countries want. These side deals get put into place without much vetting, even within developed countries such as our own. And they have a particularly focused goal on kind of stamping out piracy, anti-counterfeiting goal, which is not the same goal as putting in place the best standards, and does not even serve to mobilize political forces within developed countries such as our own that might prefer, for good reasons, somewhat lower, more difficult patentability standards and more balance. So I think that counterintuitively, having uniform international standards of patentability is not only good for global business in terms of making things easier in the global economy, but also would permit developing countries and those who want to make it harder sometimes to get patents to have a forum at which they can kind of band together and bring their arguments to the international community rather than simply being caught off in these side deals that actually lock them in to higher protection than they may want.
You? Go first. You want to go first?
So the one way to view TRIPS is to combat what we could call positive externalities, right? In fact, that's the very reason for a patent system. So imagine a world where The United States is the only country that has a patent system. The patent is published, and the rest of the world could free ride. So the idea behind this, of course, is to create some baseline. And so TRIPS tackles that problem. Section 27.1, as Professor Gervais identified, tackles that problem. So we could all agree that some level, I think we could all agree, that some level of uniformity or harmonization makes sense. Then the question becomes, how much flexibility do we want built into that harmonization? And so diversity and flexibility has two main virtues within this setting. One is, and Professor Sternberg mentioned this, is that the countries, particularly countries of the South, will be able to match their local preferences, right? They will be able to measure what information costs, how costly information should be. And this will be based on their own understanding of human capital and their own domestic institutions. And while TRIPS allows some of this, right, there are different time frames for various countries to sign on to TRIPS, to comply with TRIPS. If you're an LDC, at least developed country, you have more time. We have some of that built into TRIPS, but I'm not certain TRIPS does a good enough job as allowing the type of flexibility that would allow a country in the South, for instance, to say, you know what, I'm going to take a hard look at inventive step or term, for instance, because information is just too costly right now where we are in our growth. The other virtue, I think, of diversity, one that I think is arguably more important, it allows for more legal innovation, right? And this is part of a much broader debate in the literature of centralized and decentralized legal innovation. Even when the Federal Circuit was created itself, it's part of that debate. The idea here being feeds off of Justice Brandeis's favorite laboratories metaphor in New State ICE case in the context of federalism. That is to say, various countries should be able to experiment with their own legal systems, and this is highly beneficial to non-experimenting countries because they could take a look at this laboratory and say, you know, that really works. The difference between the local preferences argument and the legal innovation argument is that the matching local preferences arguments really works for the South.
30 seconds.
Right? With respect to the innovations argument, it works better if you have two countries whose preferences are very similar, right? Because then the country who's not experimenting could learn more, could infer, you know, if it works for them, it'll work for us. And so this notion of experimentation and legal innovation and matching local preferences seem to make a strong case for diversity.
I'm going to say something very similar, except then I come out on the other side here, so we'll see how that goes. I think that there's a simple-minded, facetious version of this proposition, and then I think there's a very sophisticated version of this proposition. I, among all the people on this panel, feel much better qualified to articulate the simple-minded and facetious version, which I will now do. The simple-minded version poses a choice, a simple choice between uniformity and diversity. And we have one side saying, oh, uniformity is good. Uniformity is good for global business. And what's good for global business is good for America, if we have any global business left in America. And it's good because it would facilitate international license transactions. And it is good because maybe it would reduce cost pressure and administrative burden on national patent offices. Then, that's one simple side. The other side says, no, diversity is good. Down with ossification in the law. We must have interjurisdictional competition. We must, therefore, stimulate innovation in the law. Here's what the more sophisticated version is. There aren't just two choices. There are all kinds of intermediate choices here. So being for the proposition, being for uniformity, is being for the recognition of at least some scenarios where we think some amount of uniformity would be helpful and actually would catalyze further innovation in the law. What it requires us to do, I think, as we think about this sophisticated version of the debate, as I'm calling it, is to think a little more deeply about who is the we, and what's the uniform. And here I'm going to echo things that really have been said on both sides of the table. So imagine one version of the we. The we is a half a dozen of the world's largest patent-granting jurisdictions. Suppose that we gets together, gravitates toward a common set of patentability standards, hoping to actually achieve better procedural harmonization mostly, perhaps hoping that these standards eventually will become de facto international standards. That's uniformity, that's uniformity that we can believe in, I think. But there might be a different we. The we, as has been mentioned, might be developing countries who would coalesce around patentability standards that would be desirable to them. And that's uniformity as well. We ought to be in favor of that. They ought to engage in that, what's sometimes been called counter-harmonization. That's one point, and I'm going to be out of time here, but we also ought to think about what we mean by uniformity. How fine-grained are these standards that we're talking about?
Time's up.
And I have to stop.
Thank you. And come back at the end.
I will come back at the end.
When approaching this idea of uniformity, I think it's important to remember that patent law doesn't simply reflect economic interests. It also reflects the cultural values of a particular country. And so while harmonized standards would reduce the transaction cost for those acting in the international patent system, it ignores the potential cultural and social sacrifices that the countries make when they make changes to their laws. So I think you can see some of this dynamic in the countries that joined the EU. They were required to harmonize their laws with that of the existing EU. Seemingly the cost benefit was in favor of them, but I think weighing and evaluating cultural costs are high. For example, and some of this I think you already see with TRIPS, where you must give chemical compound protection. It used to be that many countries did not protect chemical compounds, in large part because they thought the protection was too great. That if you've only disclosed one utility for a compound, why can you stop all uses of that compound? That's gone, right? And I think that is a social aspect that could be relevant to individual countries and their sovereignty. You can see this particularly for controversial subject matters, right? Canada denied patent protection for the Onco mouse. If we had a uniform standard, maybe the US would have to deny protection for the Onco mouse and go down. I doubt that's going to be the case, though, right? And so I think you lose that cultural context, and the ability to have that diversity reflects those social and cultural differences, which I think is a different cost that people aren't taking into account. Moreover, if you do set the standards too high, I think there's quite a bit of cost to the developing countries in implementing this patent system. In response to Professor Stanberg, one's piracy haven may be another's development opportunity. Right? Patents internationally can be viewed far more as a policy tool, policy lever, as opposed to private property. And so we always think from the Western viewpoint that any free riding is a violation of my property right doesn't necessarily translate to other countries who view it as simply as a mechanism to promote development within their own country. Now, while the bargaining, and I think the bargaining power may be shifting, right? The bilaterals have been problematic if you believe they're unfair to the developing world, but with the extension of India, Brazil, developing countries whose interests may not align with the United States, I think there's an opportunity for there to take into account development issues, tech transfer, things that have not been adequately addressed under TRIPS.
30 seconds.
If you go with uniformity, you eliminate a potential bargaining tool for the developing countries to use in their negotiations to facilitate tech transfer.
Thank you. Well, first let me give the FOR team a chance to respond to anything you've just heard on the other side.
Right. I think that Tim's last point, again, brings us back to this question of how uniform is uniform. How deep is it? How fine, how absolute is it? You know, I start by thinking of the Federal Circuit. The Federal Circuit has a mandate for uniformity. Look at the views of individual Federal Circuit judges. We would hardly say that they are uniform in every respect. Maybe, hopefully, we'd say they still have some room to innovate in the law. Uniformity, we couldn't have absolute uniformity even if we tried. So uniformity in this context really means finding the sweet spot. How much consolidation, how much uniformity can you achieve that will actually stimulate? It's a limited monopoly that stimulates innovation. That seems relevant to us, right? How much consolidation and uniformity can you have and actually stimulate innovation in the law? That's what we're looking for. If you say, let's adopt a uniform obviousness standard, you know, what are we really saying there? Are we saying let's put the word obvious into TRIPS 27.1? Are we saying, let's adopt the entirety of Judge Rich's obviousness jurisprudence? You know, all kinds of things in between. I suspect it's something far, far away from Judge Rich's jurisprudence. Lots of room for local innovation is left, and yet we still have a uniform standard.
Yeah, I just want to come back to this point about the virtues of flexibility. On one view, which was articulated, I think mostly by Professor Nard over there, TRIPS is a thing which gives us a baseline plus all this flexibility. And I think as a legal matter, that's correct. But again, as a real-life matter, what TRIPS has turned into, in many respects, is a one-way ratchet with no upper bounds on protection. One of the things you get with harmonization is you don't go directly from here to harmonization. You go through a process. And in that process, again, I just want to emphasize that the process itself might be very important in permitting developing countries to articulate their interests in a stronger and united way. And we saw that with the Doha Declaration relating to access to medicines. It's difficult for these countries when they're one-on-one with a country like the United States to stand firm. So I think the ability to have a united front may be very important, and one of the things that the process of getting to a harmonized regime would give us.
The countries like Argentina and Brazil have learned their lesson from what happened at TRIPS, and I do think you see more of a coalescing, more of an embracing of flexibility, more flexing of the muscle as represented in Doha. Now we see a little bit in tech transfer in Article 66.1 of TRIPS. Professor Janis makes a very good point when he says this is not a choice between polar opposites, that there's a huge spectrum here. And the question becomes, how much are we willing to tolerate on either end? It's really one of what is optimal. And that takes time. I mean, TRIPS is still a relatively young document. There are these built-in flexibilities to it. We have a new political economy. The South is stronger today than it was yesterday. I would just say let's embrace the diversity that TRIPS has built into it and let this process play out a little bit. We tolerate jurisdictional competition in our own country with the circuit courts. That's something we should also embrace on a global level. TRIPS is a document that legally does do that, but I also think in the real world, increasingly that's being reflected. And you write about this, Dan, in drafting history, right? There are all sorts of legal mechanisms built into it. It's just a matter of having the political power to exploit them.
2 points. The first is one I didn't get to in my first part, is that I wonder if the question is putting the primary issue, even on the behalf of the patent owners, on the wrong side, that maybe what we should be worried about is enforcement of the IP rights that we do have, right? And so if we ratchet up all these protections, great, you can get lots of patents that are never enforced anyway. So if the concern is harmonization, perhaps on the side of the patent owners, it shouldn't be on this side. It should be on the enforcement side to guarantee that whatever rights you can get actually are enforceable in a given country, and so maybe that should be the primary focus. Second, this relates to the diversity, to Professor Janis's point. It's also important to keep in mind that we are a common law country that is far different than many of the civil law systems. So the extent we would want to embrace something like this, to implement this in many civil law systems, would require a fairly finely detailed code to allow us to get some level of information, effective information about what's going on. That goes to Professor Janis's point, because it may actually be that we end up with deeper harmonization than we might expect if we really want to have an effective code. It sort of begs the question of how would we achieve this, given that we have differing legal regimes in the way that we implement our IP statutes.
Excellent arguments on both sides. Let's see if we have questions, comments. Let me ask two questions and see if they inspire additional comments. So, should we let the major patent offices, which are basically now de facto offices, not just for their own country, but for a number of smaller countries that don't have examination capabilities, should we let the USPTO, the EPO, the JPO basically develop their own guidelines on, for example, utility or non-obviousness of gene patents? Is that a good thing? Is that not a good thing? What are costs and benefits? Or conversely, should we ask the WTO dispute settlement panel to look for state practice and figure out what the actual range of acceptable standards is? Two easy questions. So if anyone wants to tackle either one of those?
I'm trying to figure out the ways in which they would be yield different outcomes. In part, that's because I'm trying to envision, under the first option you described, I'm trying to envision what these standards would look like. How detailed are they? And I guess fundamentally, the reason that I'm not as frightened about starting down that path is that at least conceptually, moving toward a uniform standard does not dictate up front what the standard is going to be, whether it's the high standard, the low standard. So I can say at least that much is conceptually at neutral. Now, we can argue about whether the political realities make that only in concept. But so that's, I'm not sure how they would be different is my answer to that, my non-answer to that question.
Yeah, I guess I have a similar type of question, and just kind of continuing on my theme here. In terms of whether either one of those approaches is really going to give us much in the way of transparency and, actual open debate about what is best to be done. It seems that I'm actually not too hopeful that, maybe in the case of the patent offices developing guidelines, in some respects there would be more transparency, at least with respect to within that country. But then there is no real mechanism for international input outside of those countries. And then with respect to the WTO, then the transparency issue just remains. So I just think both are difficult and problematic in that regard.
I would agree with that. I mean, I worry a bit about capture, transparency as well, and what type of oversight would regulatory bodies or courts have in these jurisdictions over these guidelines? What type of judicial review would they have? It seems to me that the parties who would benefit the most by imposing that type of trust and power in patent offices are likely to be those who benefit from property rights. And so unless there is a sufficient check, or we could be assured that capture is not that big of an issue, I would be hesitant to go down that path.
Was thinking along the same lines, transparency, particularly the idea that, I don't know too many patent offices that really seem to think that my concern is the public interest. It's more about, granting patents. I think whether it was the T-shirt from back in the Clinton era that says we're the patent office, not the rejection office, right? So it sort of captures the idea that they may not be as concerned about the broader public interest. The other interesting issue it poses then is related to judicial review is also just their plain authority, period, to do this sort of stuff, right? The USPTO doesn't have substantive rulemaking authority, so I'm kind of wondering about these negotiations they're doing that go beyond procedure. I think most of them are procedure-based, and that doesn't concern me as much, right? If you're harmonizing classification systems, that sort of stuff, okay, but to the extent they're actually trying to give teeth to what these rules mean, yet the PTO doesn't have the authority to do that within our own country, it seems a little bit odd to me. There's somewhat of a disconnect about their authority to actually engage in this, which seems somewhat undemocratic in some regards as well.
Quick question. Yes. Well, the question is, if I heard you correctly, is not to have uniformity. Uniformity would be more favorable to the developing world, but not enforcement. Okay. So how do we defend from a developed world standpoint? Yeah. Okay. Very good. Quick answer.
It's a perfectly good question. I think my answer would be that we're not talking about freezing in time. So you could say, you start off with patentability standards, and you know that you would have to move on to enforcement standards in order to make the system work. It says you ought to start with enforcement first and go the other direction if you really wanted to make it. That really would be my quick answer. It's a process that occurs over many years in many stages.
I think of the European model now, one of acquisition and enforcement, and there's been talk of a community patent for some time that, right now you go to the European Patent Office, so you have a centralized granting agency, but then you have to go to the various states where the costs come in, and you get a Spanish patent, Italian patent, fine, but there's no such thing as a European patent. When it comes to enforcement, though, it's up to the national court system. So you could have a patent held and valid in Italy, not infringed in France, so forth and so on. And so you need both, right? And maybe you do start with enforcement. So now the Europeans are thinking, right, we need a European patent litigation agreement to build on the community patent. I mean, you need it really at both ends, I think, to make sense. But it's an homogeneous society, right, more so than it would be if you brought it out beyond Europe. So it works in that context. But that's kind of what's going on in Europe a little bit.
Yes.
One quick thing to that, and that is, I think even when you talk about enforcement and you talk about what would it mean for it to be uniform, again, you get back to this question of what does that mean exactly. So one of the things that I personally write about quite a lot, is the question of what kinds of exemptions there should be on the back end for enforcement of patent law, things similar to fair use and copyright. So to the extent that you could have uniformity, which means you would have some kinds of exemptions which would permit you to take into account various factors, which seems to be a plausible uniform standard. Then, this might also allow adaptability not only between developed countries and developing countries, but also even within developed countries. We do not have a uniform, exact view of exactly what the enforcement should be. But if we had a standard that was uniform, then we might be able to work with it.
I was going to echo that comment as well, and and it gets to what Professor Jano was saying on the patentability side. On the enforcement side, you could say, within the U.S., do we have a uniform enforcement standard? Yes, but there is a wealth of diversity within that standard, particularly when you start talking about permanent injunctions. And so I think that is a way that you could achieve a level of harmonization, yet still preserve some level of discretion and flexibility for the countries that maybe have some concerns, right? We're just not going to offer permanent injunctions in certain contexts based off the equities or whatnot. But I think that could be a way to have uniformity yet preserve some level of flexibility.
Excellent. So, well, we're a little bit behind schedule, but let me just give each speaker a few seconds up to a minute to make a closing statement, and then we'll vote. So in the same order in which we...
I think I've said my piece.
Okay.
I'm in the same boat.
Anything you want to add?
Oh, of course. But it's only duplication. Uniformity, a level of uniformity with strings as a sweet spot, that's really what we're searching for here.
Diversity good, vote for us. Pure pandering, right? That's not for me, so.
All right, so I think a few people walked in during the debate. If you feel that you've actually attended enough to know which way you're going to vote, pick up a clicker in the box and prepare to vote. Again, 1 is you agree with the proposition that we should adopt these uniform standards. 2, you disagree. And 3, you're not sure. 1 second, please. Please vote now. Still missing some responses. 20 seconds. Ten seconds. 5. And polling is now closed. So please give me a minute to prepare the results, but stay in the room, and I will then put them up on the board. In addition to Jeopardy, do you have a drum roll, or can you do? Oh, okay. The results. Okay. Oh yes, I need to whatever I did here. There we go. All right. So, on the first proposition, which of course was, which is the best dessert, you remember that the mud pie won by 50%. Okay. On the first proposition, which was we should allow patentee to get an injunction only if the alleged infringing activity interferes with the active exploitation of the patent in suit, the proposition was defeated 65 to 25 with 10% on shore. The second proposition, we should eliminate the best mode and written description requirements. I know somebody's watching this one with great attention and rely on enablement. The proposition was defeated 62 to 29. On the third proposition, we just debated we should adopt uniform international standards of patentability. This one actually made it 54 to 42. So I think we had three fantastic debates. Do you want to say a few closing words, or should I? By the way, on the third proposition, if I had to make a short list of people in the United States to debate this uniform international standards, I would pick the people who are here. This was a fantastic debate, which I think is true of all three. But really, I very much enjoyed this international discussion at the end. So let me just, before we grab lunch, thank our speakers, first of all, and ask you to join me in thanking the extraordinary debaters. And thank all of you for your thumb muscle, which worked very well, and also the people who helped us put this together, Professor Seymour, obviously, Susan Button. I don't know if Susan is here. Is she here? She'll be back. She'll be back. Well, we can thank her in person later. Our tech people who set up the clickers and the camera. And again, this event will be web archived and available next week on the Law School's website. So I will stop here. Thank everybody again, and please grab lunch and join us for an informal discussion. Thank you.
I urge you to go outside and get your food and then bring it back in here, and we're going to have an open Q&A with the panel.